Defamation is a civil matter. Defamation occurs when false information that is damaging to someone's reputation is passed off as a statement of truth. Defamation is not just an opinion about someone, it is something damaging that is not true, but told as if it were the truth. On March 29, 1960, the New York Times took out a full-page ad about the civil rights movement in Montgomery, Alabama. The ad said some things that were not true about how the police treated protesters. As a police commissioner, Sullivan took issues with the ad and demanded that the New York Times retract the ad. When the New York Times refused to retract the ad, Sullivan sued for libel. Defamation can only occur if a third party receives the false information. The information needs to be made public knowledge in order for somebody to sue for defamation. If the information is republished in another medium, the person who republished the message can also be sued for defamation. In a defamation case, the truth is the best defense. If the information is true, no matter how damaging the information is, defamation did not occur. Defamation only occurs if something that is untrue is presented as fact. An opinion that cannot be proven to be either true or false is not considered defamation. Since defamation is a civil, not a criminal matter, damage must be shown to have occurred because of the publication of the information. If the information was said under oath in a court of law, the information is said to be privileged and not grounds for a defamation suit. If someone intentionally lies under oath in court, the person would be charged with a criminal charge of perjury and not the civil charge of defamation. Likewise, any discussion involved the functioning of government during the creation of or in the debating of the laws of the land, such as in Congress or in the Senate, is not considered to be defamation. The statement must also be a fact that is provable to be either true or false. Opinion that cannot be given a truth value, such as "this is the worst steak I ever ate," or hyperbole for parody, such as "she is so fat that she has her own gravitational pull," is not considered defamation. In order to sue for defamation, an injury needs to be shown. If a person's reputation or livelihood is not impacted by the statement, defamation did not occur. Some statements, such as saying somebody has a dangerous transmittable disease, questioning the person's sexual identity or virginity, accusing a person of committing a crime, or questioning a person's work ethics, are so egregious the injury is assumed and does not need to be proven. Other statements, such as saying that somebody smokes cannabis, are usually harmless. However, the person is crusading against legalizing marijuana. Defamation can be proven because the statement was made to damage the other person's reputation. Defamation can also be proven if someone is trying to ban alcohol and is falsely accused of being seen enjoying drinks in a bar. The reason for this is because the statement was made not out of innocence, but rather to damage someone's political stance. In general, if an untrue statement causes someone to be hated, shamed, scorned, or lose their livelihood, it is defamatory. It is hard for people with a bad reputation to prove defamation. It would be very hard for Donald Trump or Hillary Clinton to sue for defamation because their reputation is already so tarnished. In order to sue for defamation, a public figure needs to prove that actual malice occurred. Actual malice means that the person saying the defamatory statement knew the statement was false and said it anyways, or did not use due diligence to verify a statement that a reasonable person would question. In the eyes of the law, a public figure is a governmental official acting in an official capacity or celebrity that is so famous that most people would have instant name recognition, such as a very famous actor or sports star. Since public figures are better able to defend themselves against false accusations, they are given less legal protection than private people when it comes to defamation cases. The Supreme Court of the United States of America ruled that since Mr. Sullivan was a public official, damages for defamation cannot be awarded unless actual malice was proven. Since Mr. Sullivan's name was not mentioned in the ad, and the New York Times had no reason to suspect that the people who made the ad were biased against Mr. Sullivan, actual malice could not be proven. The Supreme Court also ruled that the state courts could not award public figures damages in case where actual malice was not proven. When Elmer Gertz, a lawyer hired by the family of a person murdered by a police officer, was falsely accused of framing a cop and having communist leanings, Mr. Gertz sued a right-wing magazine for defamation. Mr. Gertz was said to have been a private person and not a public figure because Mr. Gertz was acting as a lawyer for her family and not as an agent of the government. Mr. Gertz was accused of framing the cop for murder, joining a communist group bent on overthrowing the American government, and plotting a terrorist attack on police officers during the 1968 Democratic Convention. He was also accused of supporting Lenin's policies and trying to spread communism to America. The publisher did nothing to verify the facts about Mr. Gertz were true. The group that Mr. Gertz joined could not be proven to have committed any crimes against the police or even to have any ties to communist or socialist groups. No evidence was found that Mr. Gertz was a member of any communist or socialist group. The publisher posted that Mr. Gertz was a member of the Red Guild in a photo of Mr. Gertz with no evidence whatsoever to back up this claim. Mr. Gertz probably lost revenue from the defamatory story being published. The story also probably caused Mr. Gertz to endure ridicule and shame in his community. The story may have cost Mr. Gertz some clients. It was the duty of the publisher to prove the facts it published were true, and Mr. Gertz should not have been forced to try to prove that the published facts were false. In order to avoid a defamation lawsuit, you need to verify any fact before you publish it. This is especially true if the fact could damage someone's reputation. It is best to try to avoid casting someone in a negative light, even if you do not agree with what they are doing. It is also not a good idea to accuse someone of being a member of a fringe group unless you can prove that they actually are a member of the group. It is also not a good idea to say someone has very controversial beliefs unless you know for a fact that they have that belief. If you have any doubts whether or not the nice and juicy fact you have is true, leave it out, especially if it is something that could cause readers to form a negative opinion about a person or a group of people. Defamation laws in New York State are very similar to federal defamation laws. In New York, the tests of truth, publication, and injury are applied the same as they are federally. In New York, gossip is given less protection from defamation than is more newsworthy stories. In New York, if you report accurately what was said in a court of law, you are protected from defamation laws. In New York, if you republish a news story, you are protected from defamation law. The major exception to this is if you know the story you are republishing is false and still republish it anyways. In New York, if a story is edited in former content or posted on a new website, the statute of limitations resets, allowing the person who published the story to be sued for defamation. It is very important to think about defamation laws when writing a news story. When writing a news story, it is important to understand the difference between a public figure and a private person. It is important to verify any information that could be damaging to somebody is true before publishing the information. Since truth is the best defense against defamation, it is important to make sure any facts you publish are true. A word of wisdom for any journalist to live by is when you are in doubt, leave it out. If you just follow this one piece of advice, you'll avoid many defamation suits. Google is your friend. If you have any questions about defamation, it is best to ask a lawyer, but asking Mr. Google will help in a pinch.